Imagine having the power to impact our future, tackling major issues we face today: political coup, climate change, the fight against a global pandemic. In the midst of it all, will you watch from the sidelines, or will you take the lead? Do you have the passion, the perseverance, and a strong sense of critical thinking? Taylor's University offers Southeast Asia's first work-based learning international relations degree, where in your third year, you will work, learn, and be mentored by game changers in the industry. Diplomats, foreign officials, leaders from international organizations, and top scholars coming together as part of this hands-on, industry-based education, led by Malaysia's most influential, trailblazing leaders. The world is in need of visionary leaders now more than ever. Social leaders who will pioneer change. Be the next global leader now. Imagine.
Do you want to be an agent of social change, tackling issues like poverty, inequality, mental health, to be remembered as the protector of the most vulnerable? Fulfill your calling to be a prominent advocate, or simply work behind the scenes, as long as you are creating a better future for generations to come. To deal with the root causes of society's problem, you must first prepare yourself. We can help you get there. As the #1 private university in Malaysia, Taylor's University is offering Asia's pioneering degree in social innovation and change. Get involved. Spark your leadership instincts with the Emerging Leaders Greenhouse program, where you can shadow and learn from prominent national leaders, both on and off campus. Learn how we partner with leading social organizations to drive change in the society. Great leaders set out to make a difference. Lead the change you want to see in the world.
Distinguished guests, colleagues, students, ladies and gentlemen, a very good evening to all. My name is Anindita Dasgupta, and I'm an associate professor in political science and the head of School of Liberal Arts and Sciences at Taylor's University, Malaysia. Thank you so much for joining the 5th session of the Malaysian Politics and Public Issues series of talks organized collaboratively by Zubedy's Unity and Harmony Mediators Movement and Taylor's School of Liberal Arts and Sciences, Bachelor of Social Science. This fortnightly series was launched on 27th of May this year by none other than Emeritus Professor Dr. Shad Salim Faruqi himself, who spoke on the making of the Malaysian Constitution. A fortnight later, Dr. Chandra Muzaffar, President of International Movement for a Just World, delivered his talk on the making of the Rukun Negara. Subsequently, on the 14th of June, Prof. Shad delivered another very thought-provoking talk on understanding the Malaysian Constitution. And a fortnight later, Dr. Chandra Muzaffar delivered his second talk titled Rukun Negara as the Nation's Compass. And I trust many of you were here on most, if not all, of these occasions. And today we are absolutely delighted to welcome Prof. Shad back among us to deliver his much-awaited talk on Islam and the Malaysian Constitution. So ladies and gentlemen, globally, the coronavirus is testing the very strength of our social fabric and has atomized us within our individual, somewhat lonely spaces due to the very vicious nature of the health crisis itself. Now, we don't know yet what the new or the next normal will be like, but what we can see is that social life is being held in a state of suspension, one that is waiting to exhale, one that is adapting to the global turbulence and seeking to chart a new pathway to the future for the sake of our children. Now, at times like this, the values that bind us together can be a guiding light or our North Star. I remember that in his last MPPI talk, Prof. Shad had said that constitutions are born of our own unique histories as nations. And at the time of change, It is these key institutions of a nation that provide us balance as a society, remind us of our roots, and provide us a framework for the future. Now, as we stumble through the era of what some scholars have termed as post-truth, the erudite voices of thought leaders such as Prof. Shad gain even greater relevance, especially for our youth who are the leaders of the future. And in order to produce transformational leaders of tomorrow, the School of Liberal Arts and Sciences at Taylor's University has recently launched 2 degrees in social sciences. You may have just seen the videos as you walked in. One with a specialization in international relations, and the other offers Asia's first specialization in social innovation and change. So at Taylor's University, we believe that many of the next generation of Malaysian leaders will emerge from our social science program, where students will not only spend the entire final year training at various leading industries, but also be exposed to great thinkers who will undoubtedly be the source of many new questions in young and fertile minds. And for those who are joining us for the first time today, one of the flagship modules in this program is titled Malaysian Politics and Public Issues, which will be led by Anas Zubedy himself. And these lectures, these talks, these MPPI talks are being recorded, and they will be used as texts or learning resources for our students who as future leaders need to learn about this nation's journey in order to impact the future. It's my pleasure to very quickly introduce you to 2 of my colleagues who have been supporting and working very closely with Anas Zubedy to develop this module. So Ms. No Ainif Omar, my colleague, is the module leader. Ainif, over to you. You want to say a few words?
All right. Thank you, Associate Professor Dr. Anindita Dasgupta. Yes, there are 2 lecturers who are teaching this module, Malaysian Politics and Public Issues. There is me, I'm Norainif Omar. Another one is Ms. Fadila. So basically, this webinar series are a part of students' material to help them to understand the current public issues better, and also one of the ways to get the student to participate and experience the public issues matter in Malaysia. And with this method, it is important that we bring the people from the industry, not just the academic, to give a great exposure to the students. So this is one of the new, we always try to challenge ourselves to get the best way to get all this information across to students, and is one of the ways how we come to do about and to get this new approach for this module. Okay, Dr. Ninta, thank you very much.
Thank you, Ms. Noainif Omar. Thank you for that. And I know that a lot of work has been going on behind the scenes with Anas taking the lead into really developing this module. And now I'd like to invite my colleague and also one of our alumni from the School of Liberal Arts and Sciences who's joined us as a lecturer now. Ms. Fadila Raihan Lokman is the co-instructor of this module. Ms. Fadila?
Hey, thank you, Dr. Anindita. Hello, everyone. I'm Fadila. So as mentioned just now, along with Ainif as module leader, and Anas as our adjunct professor, I will also be teaching this module. So through this series of webinars, we are looking for a new way for students to actually have an active learning through engagement and interaction with experts of the fields. So this will also broaden students' understanding of topic to go beyond their textbook and the traditional classroom. And also, as you notice, these webinars are also open to all and not only limited to students. Allow me to thank everyone for being here today, and we hope your participation will further enrich our discussion tonight. Thanks.
Thank you, Ms. Fadila, for that. And ladies and gentlemen, today we are honored to have with us again Emeritus Professor Dr. Shad Salim Faruqi, who is Tunku Abdul Rahman Chair, Professor of Constitutional Law at University Malaya. Also, NOAA Foundation Tun Hussein On Chair at the Institute of Strategic and International Studies, or ICES, as well as an adjunct professor at Taylor's University. And the session will be moderated by none other than Anas Zubedy himself. So ladies and gentlemen, Anas Zubedy is the Managing Director of Zubedy Malaysia Sendirian Berhad, a training company that focuses on soft skills and making people more productive and better. Zubedy has been promoting unity extensively for the last 3 decades. Anas is a senior fellow of Human Resources Development Corporation. Anas is also an adjunct professor at Taylor's School of Liberal Arts and Sciences and director of social innovation and change at the Bachelor of Social Science, Taylor's University. I would also like to thank Dato' Loy Teck An, Group CEO of Taylor's Education Group, for making the time to be with us this evening, as many other evenings before. Enjoy the webinar, Dato'. Thank you once again very much, ladies and gentlemen. It is now my pleasure to invite Anas Zubedy to take the floor. Take it away, Anas.
Thank you, Dr. Nin. Good evening, Assalamualaikum, Samjatra. I'll go straight to the slide and I go through what I normally share, just in case there are some new people in the group today. Now, first, the why we have this program. The goal is to provide the basic foundation and framework by experts like Prof. Shad and Dr. Chandra in the subject through well thought out talks, and also create a platform for dialogue, discourses, and debates via public forums. I think in Malaysia, we are in dire need for such a platform because if you check what's happening in the social media, it is not really a dialogue, not discourses or debates. Yeah? It is very much, dog-eat-dog world that everybody attacks each other without facts, without real thinking. So the series of talks and forums will cover key topics like the Malaysian Constitution that we've been doing, socio-political history, you will hear more of that, public policies, and specific topics like education, national culture, general elections, integration, economics. So what we did was actually we organized a coursework called Malaysian Politics and Public Issues. And we designed in a way that if we want to create good citizens, we want to create good students who one day will become great leaders of the country, thinking ability, with the proper heart. So we designed this program. And from that idea, the goal of creating great citizens, we create this program called MPPI, or Malaysian Politics and Public Issues Series. Because ultimately we want to educate, discuss, and promote the exchange of ideas about Malaysian politics and public issues in a mature, rational, and justly balanced way. We need to create more talents that can discuss in a mature, rational, and justly balanced way. I feel, and my team feel, that the social media has created an avenue for people to discuss politics, not very much in a mature, rational, and justly balanced way. We need to mitigate this. So this is part, these 8 series that we have showcasing, and today is the 5th one. Yeah, it's part of a bigger coursework, and we will share more in the next few lectures. Yeah, and how we use this coursework as a mirror in our coursework, so that we can really grow talents in Malaysia, that can really think deeply and with the proper heart, for Malaysia. And today we are again very honored to have Professor Dr. Shad Salim Faruqi. Let me just quickly run by a little bit more about him. Emeritus Professor Dr. Shad Salim Faruqi is a Malaysian legal scholar and professor of law, and is currently holding the Tunku Abdul Rahman Chair as Professor of Constitutional Law at University of Malaya. He's also the 4th holder of the Noah Foundation, the Tun Hussein On Chair in International Studies at the Institute of Strategic and International Studies, ISIS, Malaysia, effective from July 2019 to June 2021. He has served University Technology Mara, inshallah. He is synonymous actually for a long time there. I think as I emailed the invitation for this program, I received at least 15 say he was my lecturer. He was my favorite lecturer. So you're a very popular person, Prof. Shad, in various capacities, the head of the Diploma of Law Program, Assistant Director, Assistant Vice Chancellor, and Legal Advisor of UTM. And I highly suggest that you read his column, yeah, fortnightly column in the Star, reflecting on the top. Prof, over to you.
Thank you very much, Brother Zubedy, Associate Professor Dr. Anindita Dasgupta and the School of Liberal Arts and Sciences for this invitation. Assalamu alaikum and good evening to all participants. Ni hao, vanakkam, namaskaram, sat sri akal, nunu habar, apachita te. I hope I've included everyone. Now, I'm going to show you some slides. I apologize that the slides are too many, about 70 or so, and time won't permit, so I'll be skipping. I hope that won't irritate you too much. Just give me a second to get things going. There you are. Right, I'm going to speak to you about Islam and the Constitution. It's a very huge topic, but let's start on it. Let me begin by saying that everywhere in the world, constitutions grow and change, formally and informally, legally and extra-legally, and the Malaysian Constitution is no exception. It is undergoing significant transformation in many, many areas, including the position of Islam in the socio-legal setup. This presentation will examine the original scheme of things in 1957-1963 in relation to the place of Islam in our document of destiny. And then secondly, the evolution of the Constitution through laws enacted in the name of the Sharia, judicial interpretations of the constitutional provisions by our superior courts, and administrative actions of civil and Sharia authorities. You'll all, of course, bear in mind that law in the book never presents the correct picture of what's going on. It's the law in action. It's what happens. In constitutional law, what's very important is what happens on the ground. The 1957-1963 constitutional scheme that was launched bore the following hallmarks. We had a Supreme Constitution. Article 4, Clause 1 says that no post-Merdeka law can violate the Constitution. Article 162, Clause 6 says any pre-Merdeka law that violates the Constitution can be either modified or nullified. There is judicial review, that is the power of the superior courts to review federal and state legislation on the touchstone of constitutionality. There is a federal state division of powers. As you all know, we are a federal state. The Constitution provides for a federal state division of power in the legislative, executive, judicial, and financial fields. And I will just concentrate on Islam, not the entire area of Islam, but only 25 areas of Islam are in state hands. I have to clarify this to all of you. It is generally believed that all of Islam is in state hands. That's an exaggeration. 25 areas of Islam are in state hands. They are mostly about Muslim personal law, though there is a small area also of Islamic criminal law. All other matters of Islam are in federal jurisdiction. Just to give you an example, contract, tort are areas covered by Islam, but nevertheless, they will be in federal jurisdiction. Fundamental rights, the Constitution in Articles 5 to 13 includes many guaranteed fundamental rights for all persons. Questions often reach the courts whether Muslims and non-Muslims are entitled to their fundamental rights against the Sharia authorities. I'm sad to report to you that our superior courts are divided on this issue. I'll say a little bit more about this later on. Then, of course, Article 3, Clause 1 declares Islam to be the religion of the Federation, but all other religions may be practiced in peace and harmony. I apologize, there's a spelling mistake there. It should be practiced with an SED. In addition to Article 3, Clause 1, in the Federal Constitution, all state constitutions except the Constitution of Sarawak declare that Islam is the religion of the state. On this point, many of you will know that in 1963, even Sabah did not have a provision on Islam in the Sabah Constitution, but later on, due to constitutional amendment of the Sabah Constitution by the Sabah legislature, Islam was inserted as the religion of the state of Sabah. Now, the provision of Article 3, Clause 1, that Islam is the religion of the Federation, is qualified by Article 3, Clause 4, which says, nothing in this article derogates from any other provision of this Constitution. Now, what's the significance of Article 3, Clause 4? Tremendous significance, actually. The significance is that the declaration about Islam as the religion of the Federation does not override any other constitutional article. No law, no institution, no procedure, no right, no duty is nullified simply because of Article 3, Clause 1. There was a famous decision in the case of Omar Cheso, 1988. In this case, a drug law was challenged as unconstitutional because it was un-Islamic. The court held that a law which is valid under the federal constitution cannot be set aside simply because it is un-Islamic. Why? Because the Sharia is not the litmus test of validity. The constitution is. However, Islam is not meant to be merely a ceremonial thing. As a consequence of adopting Islam as the religion of the Federation, a lot of other consequences ensue. It is permissible to promote Islamic education. It is permissible to establish Islamic institutions and to incur expenditure from the public exchequer for Islamic purposes. Sharia courts exist under state law since 1988. 1988, yes, they are independent of the civil courts in matters within their jurisdiction. That's Article 121, Clause 1A. There is a judicial opinion that jurisdiction means exclusive jurisdiction. So in matters in which Sharia courts have exclusive jurisdiction, the civil courts, including the federal court, the Court of Appeal, the High Court, and of course the lower courts cannot interfere. But what if the Sharia courts go outside their jurisdiction? Can the civil courts review the ultra viris or unconstitutional actions of the Sharia courts? For many years, the answer was that civil courts have no jurisdiction because the Sharia courts are of equal status due to the amendment to the Constitution in Article 121(1)(a). But in 2018, the Indira Gandhi Mutho case has ruled that only the courts protected by Articles 121 to 131(a), that is, the Federal Court, the Court of Appeal, and the High Court, have the status of superior courts, and all tribunals, including Sharia courts, are subject to the superior civil court's review power. Additionally, in the constitution, there is compulsory subjection of Muslims to the Sharia. Muslims have no choice but to subject themselves to the jurisdiction of the Sharia courts in 25 or so areas, including family law and Islamic morality. Under Article 11, Clause 4, preaching to Muslims may be regulated by state law. May be regulated. It's not shall, may be regulated. And may I clarify to you, Article 11, Clause 4 is not simply meant to prevent non-Muslims preaching to Muslims. Article 11, Clause 4 is broad enough that Muslims preaching to Muslims can be regulated. Then in Article 160, Clause 2, there is the definition of Malay. The characteristics of a Malay are such that the most important characteristic is that a Malay must be a Muslim. So Islam is one of the defining features of a Malay. Then the Constitution provides for Malay Adat. Along with Islam, Malay Adat was given clear recognition by the Constitution. And may I say this to you, that most of our Sharia laws are a fascinating mixture of Sharia law, especially Shafi law, local fiqh. Fiqh is jurisprudence, that is interpretation by the local scholars, plus Malay Adat. In case of conflict between the religious provision and Malay Adat, the latter may prevail, at least in Negri Sembilan family law courts. So different states have different attitudes towards Malay Adat, but I know in Negri Sembilan, Adat per pate will prevail over the strict provisions of Muslim property law in many matters. There's a lack of a uniform Sharia law. It's fascinating. This is not meant to be a criticism. It's fascinating because each state has its independent jurisdiction. We have 14 separate Sharia laws, 13 states plus the law for federal territories. And sometimes there are conflicting approaches to similar issues and the problem of no reciprocal enforcement from one state to another state. A uniform Sharia law by the federal parliament is legally possible under Article 76, but it will require the consent of all state legislatures plus the consent of the Conference of Rulers. Now, is Malaysia an Islamic state or is it a secular state? This question is often asked. Let me just dwell on it a little bit. Much depends on our subjective definition of secular or theocratic. We actually have a problem of semantics. By semantics, I mean different people using the same word to mean different things. Much depends on the subjective or arbitrary meaning one assigns to the word Islamic and secular. If by Islamic state means that the Sharia is the supreme law of the Federation, then obviously we are not an Islamic state because the Constitution is the supreme law of the Federation. But if by Islamic state is meant that Islam is the official religion, or that Muslims are in a majority and are in control of governance of Malaysia, then we are an Islamic state. If by secular you mean that the state does not prefer or promote any religion like in the USA, then clearly we are not a secular state because Islam is promoted vigorously by the federal and the state governments. But if by secular means that a man-made law, the Constitution is supreme, then we are a secular state. So I just want to point out to you the issue of whether we are secular or Islamic depends on your subjective definition of what is meant by secular or Islamic. My personal view is that if the Merdeka Constitution is examined, the picture that emerges is mixed. We avoided ideological purity. We walk the middle path. We have some theocratic but many secular features. Now, let's have a look at some of the secular features. If you look at the historical documents about the making of the Malaysian Constitution, clearly we were meant to be secular. If you look at Article 4, Clause 1, Supreme Constitution, Article 162, Clause 6, it's quite clear that the Constitution prevails over any other law. Article 3, Clause 4, I pointed out, says nothing in Article 3, Clause 1 derogates from any other provision of the Constitution. Many laws, institutions, and practices are based on history, custom, or these institutions are market-driven. Despite Islam's special position, the Sharia is not the litmus test of the legality of legislative or executive action. We have many historical institutions and laws that reflect the Malay way of life, that reflect the basic characteristics of the Nusantara. Among them, the hereditary monarchy, Malay Adat, and Article 153. Many laws that operate in our legal system are not in line with Islam. For example, many of our criminal laws have presumptions of guilt, and that is not in accordance with Islamic criminal law. There is mandatory death sentence for many non-hudud offenses. Banking laws allow usury. The National Land Code ignores the Islamic principle of ihya al-mawat. In other words, equitable rights are given in Islam to those who revive dead land. Mawat is dead, ihya is you give life to dead land. You have an equitable right. Family law allows Muslims to adopt children. In Islamic law, there is really no adoption. You can foster, but you don't really adopt. The link with parents cannot be wiped away. The Malaysian economy allows share market, forward trading, gambling, liquor industry, pig farming, tourism with all its seamy side. And that's not strictly in accordance with Islamic morality. Education is co-educational. Adat is entwined with Islamic law. The definition of law in Article 1 say by itself is not part of the definition of law. Law includes written law, common law, and custom to the extent recognized. Three categories of law. Sharia principles, religious principles, moral principles are not law by themselves. They need to be adopted in legislation or judicial precedent. There is higher status of civil authorities. Citizenship and high posts are not based on one's fidelity to Islam. State power over Islam is limited, as I mentioned to you. States have power only over 25 topics in Schedule 9. List 2, paragraph 1. A great many areas of Islamic banking, employment, social security, EPF, pensions, land law, taxation are inspired by secular market principles and are in federal hands. Most crimes are in federal hands. Limited power of Islamic courts. I'll have to skip that. Let me move on to the next point. However, there are many Islamic features clearly. Article 3, Clause 1, Islam is the religion of the Federation. All state constitutions except Sarawak contain provision on Islam as the state religion. Che Omar Che So, which I pointed out to you earlier, has been generally ignored in subsequent cases. Like Lena Joy, Kamaria. Lena Joy was that apostasy case where a Malay girl wanted to convert out of Islam. Titular Roman Catholic Archbishop, the use of the word Allah in the newspaper of the Roman Catholic Church. State power to enact Islamic law is limited to 24+1 enumerated topics. Federal power to enact Islamic law is there, and as a result, we have 13+1, 14 separate Islamic laws in the country. Sharia courts exist and have mandatory jurisdiction over Muslims in 25 specified areas. There is mandatory application of the Sharia to Muslims in those 25 areas. Islamic education is compulsory for Muslims. Mosques and Islamic institutions are established by using taxpayers' money. Article 121(1)(a) makes Sharia courts independent of civil courts. Preaching to Muslims can be regulated. Islamic criminal law applies to Muslims in a narrow residual area. In 9 Malay states, with the Malay Sultan states, MPs and state secretaries are reserved for Muslims. The concept of Malay is linked with Islam. Islamic institutions abound. There are large allocations in the federal budget and in the state budget for Islam. In budget 2018, federal Islamic authorities were allocated 1.03 billion as follows. I won't read the detail. This was raised to 1.4 billion in 2020. The amount does not include money allocated to University Islam or income from zakat, fitra, waqafs, halal certificates. So a large amount of federal money is allocated to Islamic institutions. Islamic practices and symbolism have become mainstream. Islamic economy is promoted vigorously. The policy of Islamization is in full swing. Islamic dress code and modesty are often enforced on all persons, including non-Muslims, administratively. The law doesn't say so, administratively. Nevertheless, in the overall constitutional scheme, we are neither a full-fledged Islamic nor a secular state. We are hybrid, we are plural, we have legal pluralism. We are a constitutional state. Our constitution is not ideologically pure. The Islamic state, which is politically a very, very appealing concept to many, it is aspirational. It is not a constitutional reality. But I must say that the movement towards more Islamization is gathering steam in West Malaysia. How will it affect the peninsular's relationship with Borneo is unknown. Much depends actually on how strongly the Borneo states object to the increasing Islamization of Malaysian society. What about theory versus reality? Since the 90s, there has been tremendous progress in the policy of Islamization and assertiveness by the Sharia establishment. Let me check my time.
You still have a lot of time. It's okay.
Thank you. Article 3 on Islam is trumping Article 4 on constitutional supremacy. In many, many judicial decisions, our superior civil courts are actually giving preference to Article 3 on Islam to Article 4 constitutional supremacy. Despite the existence of Article 3, Clause 4, Article 3, Clause 4 says nothing in this article derogates from any other provision of the Constitution. A reality check indicates that according to a critical mass of Muslim opinion, Article 3, Clause 1 on Islam has become the central provision of the Constitution. Many Malay civil court judges have proudly adopted this view. As to fundamental rights, the entire chapter on fundamental rights is being read subject to Article 3, Clause 1. Specifically, freedom of religion of Muslims as well as non-Muslims is being subjected to Article 3. For example, the Herald decision on use of the word Allah in the Herald publication, the court decided that Article 10 on free speech and Article 10 on freedom of religion is subject to Article 3 on Islam. How the court made this decision is quite fascinating, because Article 3, Clause 1 on Islam is accompanied by Article 3, Clause 4, but the courts ignored Article 3, Clause 4. Muslims are under severe thought control. there are clear attempts to restrict the right to speech and expression of Muslims. The banning of books, preventing foreign Muslim scholars from coming to the country, requirement of a Tawliya accreditation. Muslims cannot speak about Islam unless they have a permission from the state authorities. Criminalizing the questioning of fatwas. In some cases, the Home Minister bans books, not because the Home Minister is satisfied that the book is a threat to security and public order, but because the religious authorities protest. So under the Printing Presses and Publications Act, it's the Home Minister's power, but the Home Minister basically acts on the request of the Sharia authorities. State law bans non-Muslims from using 30 to 35 Arabic or Malay words without linking the usage to either public order and national security in Article 10, Clause 2, or the ban on proselytization in Article 11, Clause 4. Let me explain this point. Article 10, Clause 1A gives freedom of speech. However, Article 10, Clause 2A says speech can be restricted by law on grounds of public order, national security, incitement to an offense, friendly relation with other states, contempt of court, contempt of parliament, defamation, morality. So in my view, speech can be restricted on these enumerated grounds. But actually, many state laws are banning the use of 30 to 35 words without invoking any of these grounds. I suppose they are banning the use of these words on the ground of Article 11, Clause 4, that no one can preach to Muslims. So basically, any use of the word 30 to 35 word would be regarded as preaching. I think that is too far-fetched, too far-fetched. There is no clear link between someone saying Assalamu alaikum to a Muslim, a non-Muslim saying Assalamu alaikum. Does that mean he's preaching? Well, the way the law is today, it amounts to preaching, banned by Article 11, Clause 4. There are many other laws, state laws, which could possibly be challenged. There are attempts to control Muslim trusts because it is a waqf, therefore it must be controlled by the state authority. Some people may say this is a violation of Article 13, Clause 1 on the right to property, violation of gender equality in Ratu Chante contests. Now, don't get me wrong, I'm not supporting Ratu Chante contest. My objection is this: if Ratu Chante is an Islamic and is to be banned, then bodybuilding contest must also be banned, because the rule of modesty in dressing applies to both males and females. Cross-dressing, Negri Sembilan bans cross-dressing for males. It doesn't ban cross-dressing for females. So that's gender discrimination. Criminalizing of apostasy may well be a violation of freedom of religion, freedom of speech, criminalizing of cross-dressing. So there are a lot of state laws that actually are questionable on grounds of fundamental rights. State power to punish Islamic crimes. Schedule 9, List 2 gives power to the state assemblies to create and punish offenses against the precepts of Islam. Under this provision, state laws are being enacted to arrest Muslim apostates, detain them, and try forcibly to rehabilitate them. Issues of freedom of religion in Article 11 are not being addressed by the courts. Neither is the issue being noted that prisons and rehab centers must be under federal power. All prisons and rehab centers are in federal hands, but actually many states are running prison and rehab centers. So when it comes to federal state division of power, when it comes to fundamental rights, the civil courts are turning their face away. They're looking the other way and permitting these state laws to violate the Constitution. There are, however, some honorable exceptions. In 2021, I think January or February, there was a famous case of Ikiputra, I-K-I, Ikiputra. What had happened was that the Selangor law punished homosexuality by Muslims. The Muslim being prosecuted went to the court and said, Selangor has no power to pass such a law because homosexuality by males is a federal offense under the federal penal code. And therefore, the state has no power to pass this law. And the federal court agreed. Please don't misunderstand the federal court decision. Federal court did not say that homosexuality is a fundamental right. No, it said the homosexuality law is a federal law. The prosecution must be commenced in a federal court, not in a Sharia court. So there are exceptions, no doubt. In Negri Sembilan Fathul Bari case, Fathul Bari was prosecuted for speaking without a tawliya, without an accreditation. He said, but what about my fundamental right to free speech? What about my right to religion? State law cannot violate. The courts, however, disagreed on a technicality. The court overruled a beautiful court of appeal. The federal court overruled the court of appeal. And the federal court interpreted the words precept of Islam very, very broadly to include all matters of Sharia, law and morality, including control or deviationist teachings. So Fathul Bari won a case in the Court of Appeal, but federal court overruled the Court of Appeal. Moral policing is on the increase. There is punishment for deviationist teaching. Muslims are increasingly being subject to regulation on issues like speaking without a tawliya, apostasy, banning of books, the CIS forum case, prevention of foreign Muslim scholars, etc. Victimization of Muslims with differing views. There are fatwas against secularism, liberalism, pluralism, without precisely defining these terms. Some Muslim lawyers are refused renewal of certificates to practice in Sharia courts. In one case of Nick Abdulaziz, a Muslim store manager, was prosecuted and persecuted for working at the Borders bookstore that sold a book disapproved by Javi, but the book was not legally banned at the material time. Javi defied the High Court, the Court of Appeal, and the Sharia High Court in continuing its harassment of Nick Raina. The Herald case of the Kalima Allah upheld the ban on the use of Kalima Allah in Christian materials. This decision has aroused the anger of Sabah Sarawak Christians. There are tensions over delays in granting planning permission for non-Muslim places of worship, and because of relocation orders on religious places. Though I must confess, many of these religious places are constructed illegally. There's a serious problem of religious places constructed without proper local authority permission. There is intense competition between evangelical activities of Christian missionaries and da'wah activities of Muslim missionaries in Orang Asli areas and in Sabah Sarawak. In Sabah Sarawak, Sharia courts and native courts have intense competition. I have to skip these, sorry. State power over Islamic crimes should not cover matters in the federal list or matters dealt with by federal law. However, there are many state laws that actually cover federal matters. For sometimes these laws are quite justifiable, morally speaking, or public interest wise. For example, Muslim couples wanting to marry must get an HIV test undertaken. Very good law. But nevertheless, the point is this: infectious diseases are a federal matter. So the law must be a federal law. A state requirement of such matters is, strictly speaking, outside of state jurisdiction. Some states are passing hudud laws on such matters as theft, rape, murder. Others are punishing betting. Almost all state laws punish betting, but betting is a federal matter. Lotteries are a federal matter. Gambling is a federal matter. Homosexuality is a federal matter. So the states are overreaching. Without doubt they are. I'm skipping lots of slides, sorry. Now, by way of conclusion, what I want to say is this, that like all other religions, Islam is a mansion with many rooms. In other words, diversity is not unknown in Islam. Allah subhanahu wa ta'ala permits it. The Holy Quran permits it. The Muslim community in Malaysia is deeply divided over such issues as implementation of hudud, moral policing, the Kalima Allah issue, and some actions by Sharia authorities. There are currents and cross currents. Some time ago, the former MB of Negri Sembilan issued a divorce first, convert afterwards policy. What was happening was that some, not all, some non-Muslims in an unhappy marriage didn't want to divorce under the Civil Law Act, under the civil law, not civil law, under the civil law, and therefore they adopted the easy way of converting to Islam. And because they have converted to Islam, therefore their marriage with the non-Muslim partner will have to be invalidated. So easy way out of the unhappy marriage by becoming a convert to Islam. The former MB of Negri Sembilan issued a policy saying, if you want to convert to Islam, settle your marital issues first. Go to the civil court, get a divorce first, then convert. I thought this was a very humane policy. Some states have very tolerant laws on Muslim apostates than others. In some states, becoming an apostate is not a criminal offense. However, there is a waiting period, a cooling off period. Negri Sembilan is one of them. However, the Lina Joy decision to give Sharia courts exclusive jurisdiction over someone who no more professes Islam is a big hurdle. Despite harassment and threats, a number of NGOs like Sisters in Islam, G25, Islamic Renaissance Front continue to raise their voices of concern against abuse of power by state legislatures and the wrong priorities of the Sharia administration. One Mufti, the Mufti of Perlis, is often critical of the obscurantist direction that Islam is taking. Looking at the Constitution as a whole, the original constitutional scheme was to divide powers over Islamic law between the federal and state authorities. The states were not given a monopoly over the entire field of Islamic law. The Constitution assigned powers to the states in only some enumerated areas, mostly of family law. However, since the 80s, the states are enacting legislation in areas which are outside their jurisdiction. The federal government is a silent spectator. The courts are reluctant to strike down ultra vires laws by the states. Some courts are reluctant, others on the other hand have been quite assertive to say no, the Constitution must be followed. The Constitution expressly forbids the subjection of non-Muslims to the jurisdiction of the Sharia authorities. Schedule 9, List 2, Paragraph 1 is explicit. Sharia courts have jurisdiction only over Muslims. Regrettably, some Sharia authorities are emboldened to break free of this limitation. What they do is when a Muslim marriage, sorry, a non-Muslim marriage is unhappy and one of them converts to Islam, Sharia courts accept jurisdiction. They dissolve the marriage. Now, they are not just dissolving the marriage of the Muslim convert, they are also dissolving the marriage of the non-Muslim, and that is outside their jurisdiction. They give custody and guardianship of the non-Muslim children to the Muslim parent. They convert the non-Muslim child to Islam. And I think in that respect, they are violating Schedule 9, List 2. However, the Indira Gandhi decision has in 2018 tried to correct this trend and said, no, the Sharia courts have no authority over the non-Muslim spouse. The non-Muslim spouse has an equal right. So there are currents and cross currents. Muslims are divided. Article 3 and the 9th schedule have overridden constitutional supremacy if one were to look at some judicial decisions. However, this is not something which is unanimous. Muslims are divided. Muslim judges are divided about whether the increasing Islamization of society is commendable or objectionable development. There is ferment and foment, and I think this is an issue that in one area definitely is capable of tremendous problems for us, and that is in West Malaysia's relationship with Sabah and Sarawak. So there is ferment and foment, and only time will tell the state of affairs to come. Thank you very much.
Thank you, Prof. Shad. Thank you very, very much. You have managed to share the bigger picture and also some details. Very helpful, and I think there'll be more questions, more answers. But now I have 12 questions already sent via the registration. As usual, we will always go through the questions sent earlier, and if we have time, we will take the questions posted during the talk. I shall share my presentation, which I normally put the questions nicely. The first question has both a general and also a specific. It is by Lim Sau. He asks, how much have we deviated from the original intent of the Constitution compared to now? Allow me to repeat. From Lim Sau, this question has both specific and also general interest.
Yes.
Anas, we don't see your slides, Anas.
It's okay. Can I answer the question? Anas, can I answer your question? Can I go ahead?
Yes.
Yeah. Okay. The question is, how much have we deviated since 1957-63 from the original intention of the Constitution compared to now? Thank you, Mr. Lim, for this question. Now, in terms of the Constitution itself, I don't think there has been any significant change made to the federal Constitution. Article 4, Clause 1 is still there. It doesn't say the Sharia shall be the supreme law of the Federation. There is no such change. In some countries, changes like that were made. Article 3, Clause 1 is still in place. Article 3, Clause 4 is still in place. The main changes, however, that were made have been that Article 121 brackets 1A was inserted to say that Sharia courts in matters within their jurisdiction shall be independent of the civil courts. But I want to alert you, Article 121 Clause 1A says Sharia courts in matters within their jurisdiction. So the question of jurisdiction is still open to determination by the superior courts. But in matters within their jurisdiction, Islamic marriage, Islamic inheritance, Islamic gifts, hiba and others in matters. The most significant change to me, Mr. Lim Sawu, is that Article 161C and Article 161D were amended, in fact repealed in 1976 to the detriment of the rights of Sabah Sarawak. What does Article 161C say? What did it say before its amendment in 1976? 161C stated that if any federal law gives special aid for Islamic education and Islamic institutions in Sabah and Sarawak, then that law requires the consent of the governors of Sabah Sarawak. They repealed this law. 161D was an exception to Article 11 Clause 4. 11 Clause 4 says that no one can preach any religion to Muslims. In relation to Sabah Sarawak, Article 161D said, no such law shall be passed for Sabah and Sarawak except by a 2/3 majority. This was amended. So may I sum it up by saying that the Islamization of Sabah Sarawak was promoted by repeal of these two laws. So in terms of constitutional amendments, except for 161C and 161D, I don't think anything significant has been amended. However, administrative practice has significantly been affected in the last few decades. So just a few days ago, for example, I read in the papers and I was quite embarrassed and sad, but there was a happy ending. A non-Muslim lady had gone to a COVID-19 center, but her dress was slightly above her knee, and she was refused permission by the guard to go into the health center. But fortunately, the supervisor overruled the guard and allowed her to go in. So I think these administrative practices are definitely impinging and infringing on the rights of Muslims as well as non-Muslim. I'm told that in Kelantan, if Muslim girls are wearing pants or jeans, they're often hauled up and asked to go back home and dress properly. So administrative practices have significantly changed, but not the Constitution. On this issue, the Constitution is pretty much the same, except for 161C and 161D. Thank you, Anas. That's all I have to say.
Let me go to the second question. Thank you, Lim Sawu, for a very good question. The second question is by Dr. Loganathan. How do you reconcile the issue that on one hand, Islam is a religion of the Federation, and on the other hand, Islamic laws are state laws? That's one. Be that as it may, it seems to either run parallel with federal laws and at times even superseding federal laws. You have spoken about it. Maybe you want to give a short summary.
Yeah. Well, ideally, Dr. Loga, ideally, there should be one set of laws and one institution creating laws for all Muslims. But the problem was this, that in 1957, when our document of destiny was being crafted, the Malay sultans wanted to preserve Islamic law in their hands, because that is one of the sources of their authority and their prestige. So I think that was a concession to the sovereignty and power of the Malay sultans, that every state preserved the power of the sultan on the matter of Islam, and not just Islam, actually Malay Adat. So Islam is in state hands. But of course, I fully concede that this leads to problems of reciprocal enforcement. Husband may be from Kelantan, wife may be from Selangor. Which law applies to their marriage? So I think sometimes there are problems if, God forbid, there is a divorce or there is some dispute. So there is a multiplicity of laws. There is a problem of reciprocal enforcement. However, on the second part, Dr. Loga, the second part, that sometimes the state law supersedes federal law. I have to clarify that. A state law must supersede a federal law if the topic is in Schedule 9, List 2, Paragraph 1. If a topic is one of those 25 topics. But if the topic is not in Schedule 9, List 2, Paragraph 1, then there is no way the state law can supersede. So may I just give you an example? Let us say the federal government is angry that there are 14 separate marriage laws for Muslims. So it passes Uniform Muslim Family Law Act 2021. So all the states now are subject to a uniform Muslim family law. I don't think this uniform Muslim family law is constitutional. It is clearly illegal because marriage is in state hands. So in answer to your question, Dr. Loga, state law cannot override federal law on topics in federal hands, like the example I gave you of Iki Putra, where homosexuality has to be in federal jurisdiction. That's all. Thank you so much. Thank you, Anas.
Thank you. Yeah. Let's go to the next question. Yeah. This is something quite debated for some time. I remember, even when I was in university, I still remember this. Why is the word is used instead of shall be in Article 3? Maybe you can share a bit more about Article 3. Is it related to the odd dichotomy? Article 3 only meant to recognize an existing fact and not any legal norm or impose legal duty by Julius. Yeah, I remember this, even university days, there was a debate about this, Prof.
Thank you so much, Julius. This is an incredibly searching question.
Yes, correct.
And I'm quite incapable of answering it. Let me just, however, point out that not just Article 3 uses the word is. Islam is the religion of the Federation. Many of the articles of the Constitution, I notice, also use similar words. Article 4, which to me is the heart and soul of the Perlembagaan, says, this Constitution is the supreme law of the Federation. So it doesn't say this Constitution shall be the supreme law, is the supreme law of the Federation. And any law passed after Merdeka Day, which is inconsistent with it. I notice Article 8, Clause 1 on equality says all persons are equal before the law. It doesn't say all persons shall be equal. Article 10, Clause 1 on freedom of speech says every citizen has, doesn't say every citizen shall have. Article 11, Clause 1 on freedom of religion says every person has freedom to practice, to profess his religion. So I don't think the word is in Article 3, Clause 1 was meant to treat Islam as something unimportant, because otherwise the word is appearing even in Article 4, Clause 1 would be regarded as something not important. So I don't think the word is was meant to avoid any legal effect. I don't think the word is was meant to de-emphasize the impact of Islam or of the Constitution. However, I would agree with you. Many other articles in the chapter on fundamental rights, like Article 5 on personal liberty, no person shall be deprived of his life or liberty save in accordance with law. Article 6 on slavery, Article 7 on no retrospective criminal laws, Article 9 on prohibition or banishment use the word shall. So in answer to your question, I can't really answer this question adequately. I'm grateful to you for pointing this out. I've learned from you. Thank you very much. Actually, I have to say this, in many respects, one keeps on learning. And this is a learning experience for me, what you pointed out. Anas was fortunate to know of this issue earlier. This is the first time I'm hearing this. And I thank you for adding to my my limited knowledge on this issue. Thank you very much. But that's all that I have to say. Thank you.
Thank you, Prof. Let's go to the next question. And you're very humble, Prof. very humble.
No.
Okay, the next question by Philip Yo. To what extent has the religion of the Federation clause in the Constitution been hijacked in practice? You've spoken a little bit about it just now. What can civil society and the legal fraternity do to stem this tide?
Thank you so much, Mr. Filipio. I presume what you mean is that Article 3, Clause 1 has been extended too far, has been interpreted too broadly, despite Article 3, Clause 4. I agree that Article 3, Clause 1 was qualified by Article 3, Clause 4, but Article 3, Clause 4 has not been given the significance it was due. Now, how do we stem this tide? That's a tough question, and I have to answer it politically rather than legally, because as I said earlier, the law has not significantly changed. In Pakistan, for example, in 1984, I think, they amended their constitution to say the Sharia shall be the supreme law of the Federation. Malaysia has not done that at all. However, politically, of course, Islam has been politicized, and the idea of an Islamic state has become a matter of great political appeal around every election time. In fact, I'm speaking in a light-hearted way. Every time someone talks about the Islamic State or the hudud, I tell myself, elections are coming. It's a good indication. It's a weather vane for an approaching election. The issue of hudud is being revived. What can be done? Well, first of all, we all have a right and we all have a duty to speak up if the Constitution is violated or interpreted wrongly. If there is overzealousness, we have a duty to speak up. Now, in my view, actually, this debate is ongoing within the Muslim community, though it has to be intensified. Groups like G25, Sisters in Islam, IRF, there are many Muslim NGOs on both sides. Some are promoting the Islamic State, and some are actually saying we don't need an Islamic State. The idea of an Islamic State is actually not necessarily in accordance with Islamic jurisprudence. It's an idea that came much later in Islamic philosophy. When Prophet Muhammad went to Medina and he drafted the Medina Charter, he never talked about an Islamic State in Medina. He basically talked about the communities, the Jews, the Christians, the Muslims living together. So I think there is a great deal of interaction going on, a great deal of internal debate going on. However, some of this debate is muted because many Muslims will speak privately but not publicly on this issue. They are worried about being prosecuted without not having that tawliyah. Now, I just want to mention this to you, Mr. Philip, that we are facing, all of us, we are facing one of the challenges of democracy. The challenge is this: in a democracy, to win votes, to win elections, you have to appeal to the larger public. And if public opinion polls indicate that the Islamic State argument is popular with the Muslim electorate, then understandably many Muslim politicians jump onto the bandwagon to win votes. So what I'm saying is this, that the idea of an Islamic State, the idea of hudud, has tremendous political appeal to a large number of people. For various reasons, ever since the Iranian Revolution of 1979, and of course the influence of Saudi Arabian money, the petrodollars, the establishment of religious schools, international financing of these religious schools. So this is the challenge of democracy. What, however, I will point out to you is this. No movement is ever eternal, and no movement is ever linear in one line. Life goes in circles or in spirals. Now, remember this, that in the 70s, if you were an advocate of the Sharia, of the Islamic State, of the hudud, you were blacklisted by the police. You were a danger to the stability of society. I know this for a fact, that if in the 70s you were on that side, you were observed. But now life has moved in circles. Now it's the other way around. But this could change. I'm told that in Pakistan, the Islamic State movement has lost some of its steam. I'm told that in Saudi Arabia, the present crown prince, whatever your view about him may be, he has many faults and many strengths. He is trying to bring about some liberalization. So I have no answer to this. I think we all have to speak up, but respectfully and within the limits of the law. And institutions like UIAM, University Islam, ISTAC, IKIM, IAIS, and Muslim scholars can play a role in promoting a vision and version of Islam that emphasizes good governance, that emphasizes lack of corruption, that emphasizes not just rituals, but the values of Islam. So I hope that's the vision and version of Islam that could be promoted rather than emphasis on rituals. But this is the problem of democracy, and of electoral system, that basically people say and do whatever is popular rather than whatever is necessary and whatever is desirable. Thank you.
Thank you. Thank you for a very well-rounded answer, Prof.
Thank you. Thank you.
Let me go to the next one. Yeah. It has been argued that JAKIM is unconstitutional because it is a federal encroachment upon the state's jurisdictions, and also because it interferes in the authority of the sultans, who are the heads of Islam in their respective states. Is there any merit to this argument? I think this has been brought up quite a few times and debated. Your views?
Under the Federal Constitution, Article 3, Clause 5, it says that Parliament may by law make provision for regulating Islamic religious affairs and for constituting a council to advise the young di Pertuanagon in matters relating to the religion of Islam. So it is not unconstitutional for federal parliament in respect of federal territories and areas where the king is the head of Islam. And by the way, he is the head of Islam in 7 territories: Sabah, Sarawak, Malacca, Penang, and the 3 federal territories. Plus, he's also the head in his own state. But in his own state, the state law will apply. So to advise the young di Pertonagong, federal parliament can set up a council. Now, as far as I know, JAKIM was not set up by a federal law under Article 3, Clause 5. Nevertheless, I don't think JAKIM is unconstitutional if it simply advises, if it simply issues opinions, in much the same way University Islam or ISTAC or IKIM or IAIS may prepare papers and opinions on Islamic affairs. But if JAKIM were to issue orders, were to try to overrule or usurp the powers of the state fatwa committees, then there is a problem. If JAKIM prosecutes someone without authority of law, that is clearly unconstitutional. So it should confine itself to advising the young di Pertonagong. That's all, advising. But it cannot prosecute because it's not created under a law, unless it has a legal statutory authority. And surely I agree with you, it cannot violate the powers of the sultans and the state authorities. There are so many state authorities which issue rulings on Islam. And I agree with you. Actually, some sultans can and have sometimes banned their officers from dealing with JAKIM. I remember last year or a year before, Sultan of Johor banned his Sharia authorities from dealing with JAKIM and said, JAKIM should leave Johor because in Johor, the Johor Sharia authorities under my control will determine what is Islamic and what is un-Islamic. Thank you.
Thank you. Anwar Ghani, we have 2 questions about Sabah and Sarawak. Freedom of religion was promised in the Intergovernmental Committee and Executive Report and enacted under State Constitution of Sabah. It was also part of the 20-point agreement. The State Constitution was amended in 1973, as you spoke earlier, and to make Islam the state religion. Is this legal and is there recourse back to the pre-1973 position?
Yeah, I agree with you, Anwar Ghani, and actually there's another question by Mr. Siva Palan, similarly on Sabah Sarawak. We'll be coming to that soon. I agree with you that for Sabah Sarawak, the IGC report, Intergovernmental Committee report, the 20 points of Sabah, the 19 points of Sarawak, gave to Sabah Sarawak a lot of autonomy in matters of religion and in many other matters. And in many respects, the policies of the federal government since 1963 have violated the terms of the IGC and the 20 points. Earlier, I had the privilege of pointing out to you that Article 161C and 161D were amended by the federal parliament, not amended, repealed by the federal parliament. And I think that was a violation of the rights of Sabah Sarawak. However, Anwar, this amendment, to be valid, should have gone to Sabah Sarawak's governor for consent. I hope the consent was obtained. If the consent was not obtained, these amendments or repeal of 161C and 161D can be challenged in a court of law. As to Sabah adopting Islam, Anwar, I have to say this to you. It's not the federal government that adopted Islam in Sabah. It's the Sabah government and the Sabah legislature that amended the Sabah constitution to adopt Islam as the religion of Sabah. So the blame, if any, or the praise, if any, depending on how you look at it, should go to the Sabah government. The federal government didn't interfere here at all. Now your question is, can we go back? When it comes to 161C and 161D, to go back, yes, one can go back, but the federal government will have to initiate, because this is an amendment to the federal constitution. But when it comes to Sabah, Islam being the religion of Sabah, federal government was not involved, is not involved, and Sabah can do it all by itself. So it's a Sabah matter. I have to say this to you with some sadness, that many of the rights of Sabah Sarawak were violated not by the federal government, but by the past Sabah Sarawak governments. So for example, Labuan became a federal territory. It was with the consent of Sabah. The consent should have been withheld if you didn't want Labuan to be taken away by the federal territory. Thank you. That's all for Anwar's question.
The second question from Sabah and Sarawak. How is Islam applied in the constitution with reference to Sarawak and Sabah when both these states have different social, political, and religious experience, both from historical and spatial perspective? I think it's a very wider question.
Yeah, actually, I agree with you, Mr. Siva, that Sabah, Sarawak, especially Sarawak, is a multi-religious, multiracial society. I understand that in Sarawak, the majority of the population is non-Muslim. All the natives combined together are a majority. I understand that Muslims are not a majority in Sarawak, and of course, in Sarawak there is no state religion. There is no religion in the constitution of Sarawak. So I agree, we are a multi-religious, multiracial society, especially so in Sabah and Sarawak. However, I want to mention this to you, that in 1962-63, when negotiations were taking place, Sabah Sarawak did not object to Article 3 on Islam being the religion of the Federation, as long as there was that guarantee of Article 161C and 161D. There was in 1963 no demand from Sabah Sarawak to repeal Article 3 on Islam. There was no demand to make Malaysia a secular state. But I acknowledge with sadness that actually the West Malaysian government has made attempts to extend federal policies on Islam to Sabah Sarawak, and I think the federal government should be more sensitive to the sensitivities of Sabah Sarawak. I disagree with decisions like the Kalima Allah issue, because in Sabah Sarawak, I understand for centuries, they have used Bibles in Bahasa Melayu as spoken in Sabah Sarawak, and the word Allah has appeared in the Bibles in Sabah Sarawak. So I think in this respect, West Malaysian judges, West Malaysian politicians have been insensitive to the beautiful mosaic that Sabah Sarawak are. And I want to say this to you from my own experience of having visited Sabah Sarawak many times. I think West Malaysia should learn a few lessons from Sabah Sarawak, how to live together in peace, harmony, tolerance, and mutual respect with each other. In my personal view, living together in peace and harmony, in tolerance and mutual self-respect is a sign of a great civilizational. It is a civilizational quality. And I want to say this to my Sabah Sarawak friends here. you are doing better than us in West Malaysia. Thank you.
Thank you, Prof. We have a few more questions. Okay to just continue, yeah? A few more. Is there a space, this is by Johnson Chong, is there a space to have a public discourse about the relevance and or removal of certain constitutional provisions that relate to, for example, Islam and the rulers? If they are, when are the discourses deemed seditious by the authorities?
That's a tough question, and I will just give you the legal point, but of course, you'll have to exercise your judgment. Public discourse on sultans and on the Islam actually does take place quite often. For example, during this emergency period, the Sultan, the Yang di Pertonagong, last September refused to declare emergency. Do you remember this? Last September, he refused to declare a national emergency. Many people said Sultan must act on advice. And Article 40, Clause 1, 40, Clause 1A. On the other hand, some said no, declaring emergency in Article 150, Clause 1 is a personal prerogative, because Article 150 says, if the Yang di Pertuanagong is satisfied that state of affairs exists whereby. So it's a personal discretionary power. So I think the Agong's discretion in relation to Article 150, Clause 1 was discussed. Openly, it was discussed in the media, in articles, on the issue of Islam. I think there are quite a lot of articles and books written about Islamic policies, Islamic banking, Islamic criminal law. So I think public discourse is not entirely banned. However, because of the Sedition Act, you can't question the existence of the position of the sultans. You can't question the existence of Islam as the religion of the federation. So you can question the implementation of policies, but you cannot question the existence of these institutions. You can't insult them, because if you insult, that would be not only a violation of the Sedition Act, it'll be a violation of many sections of the penal code. I think section 298 and 298A of the penal code. So public discourse is allowed, but within limits. We can question the implementation of the law, but not actually the existence of the institutions in a disrespectful way or in a threatening way. That's all that I have to say.
Thank you, Prof. Prof, we'll take a few more questions, yeah?
Yeah, no, go ahead. Go ahead.
But it's already 9:30. This is from Shashi Kumar. Does the Constitution specify what ideology of Islam is allowed to be practiced in Malaysia? Does it allow a differing ideology or ideologies, maybe mazhab, maybe we can use, of Islam brought forth by foreign preachers? Example given, he gave was Zakir Naik. Yeah.
Yeah, thank you very much, Shashi. The federal constitution, as far as I can see, nowhere defines the word Islam. It doesn't say Shafi Islam, Hanafi, Maliki, Hanbali, Ithna Ashari. It doesn't. But many state laws clearly specify that Shafi school, Shafi sect of Islam shall apply. On the other hand, let me also quickly point out to you that many state enactments recognize the diversity that is inherent in Islam. And in some state laws, they don't use the word Shafi'i law. They say Hukum Sha'ara, which actually is much broader. And I know for a fact that Sharia courts are generally receptive to diversity of jurisprudence in terms of Hanafi, Shafi, Maliki, and Hanbali. Even the Shias are recognized as part of Islam. They are recognized as part of Islam, but lately there have been some statements that the Shia version of Islam is to be discouraged. But Shias have not been declared to be non-Muslims. There are some subgroups of Islam that have been declared to be non-Muslims. In almost all states, there are three ways of regulating Islamic ideology. One is that there is criminalization of deviationist teaching. Secondly, in some states, they don't punish, instead they excommunicate. They say, you are out of the pale of Islam. And thirdly, as I mentioned to you earlier, there is this requirement of a ta'uliyah. You can't speak about Islam. So yes, Islamic ideology is regulated. In many states, more than in other states. But as far as the Sharia courts are concerned, surely they recognize Hukum Sha'ara and not just the Shafi school of Islam.
Thank you. Thank you, Prof. I will take another question here by Helen K. What does the Constitution say about Malays and the religion of Islam? You spoke about it earlier. Can the Malays choose another religion instead of being Muslim by birth?
The Constitution nowhere permits or bans apostasy. The Constitution says preaching to Muslims can be regulated. Article 11, Clause 4. But if a Muslim by himself studies another religion, there is no ban. I have on my bookshelf the King James Version of the Bible. I think the Bible is one of the most beautiful pieces of literature. I quote from it quite often. There is no ban on that. Now your question is, can a Malay convert? If a Malay converts out of Islam, right away he will cease to be a Malay. Because under Article 160, Clause 2, the definition of a Malay has 4 characteristics. The first one is, person must be of the Muslim faith. Secondly, he must follow Malay Adat. Thirdly, he must speak Bahasa Melayu habitually. And fourthly, either he was born in Malaya or in Singapore before Merdeka Day, or he is descended from one parent who was so born in Malaya or Singapore, or was resident in Malaya, Singapore before Merdeka Day. So being Muslim is part of the Malay makeup. When it comes to apostasy, the various state laws are quite divergent. In some states, apostasy is criminalized. It is an insult to Islam. In other states, there are procedures of cooling off period. A person cannot apostate right away. He has to apply to the Sharia court, and they will then try to win him back. There is a cooling off period. Period used to be 90 days, increased to 120 days or 160 days, that kind of thing. However, the federal court in the Lena Joy and scores of other decisions have said that apostasy of a Muslim is a matter not for the civil courts, is a matter for the Sharia courts. So the Sharia court will decide whether a person is or is not a Muslim. So obviously the procedural hurdle is there, virtually impossible for a Muslim, Malay Muslim to apostate because of the procedural. However, let me clarify. The rule against apostasy is very strict if a Muslim who was born a Muslim wants to apostate. But if it was a mu'allaf, a person who had converted to Islam, then it is not so strict. There are many cases on record where a person had converted to Islam to marry someone. Then the marriage fell apart and the person wants to go back to his original religion, and he was allowed to do so. There have been cases where a Muslim man and a non-Muslim woman had a sexual relationship. An illegitimate child was born of that union. The child was in the custody and guardianship of the mother, brought up as a Buddhist. Recently, there was a case in January like that in Selangor. And the court said, since the child was never a Muslim, illegitimate child was never a Muslim, was brought up by his mother, therefore the child, there's no question of apostasy. It's not apostasy. The child was never a Muslim. So that's all that I want to say. Apostasy for a Malay Muslim is procedurally difficult, though theoretically possible. Procedurally difficult. But for someone who is a mu'allaf, it's a very different story. Thank you.
Let's hurry to the next question, Prof. If Malaysia, this I think is someone not Malaysian. Yeah. If in Malaysia, if a non-Muslim wants to get married to a Muslim, he must first convert to Islam prior to marriage. Is this requirement mentioned in the Constitution? On the same matter, if a Malaysian non-Muslim gets married to a Muslim overseas and the marriage is registered at our embassy, is the marriage recognized in Malaysia? Is a non-Muslim spouse required to convert on returning back to Malaysia?
That's a tough question, Abraham. I'll answer it like this. The Constitution nowhere says that Muslims must marry only Muslims. It doesn't say that anywhere because marriage is a state matter. And basically, the state law will not recognize, does not recognize a marriage between a Muslim and a non-Muslim unless there is a conversion of the non-Muslim. So this is a state law. Now, the states will just refuse to solemnize the marriage. So that's the basic issue. And then sadly, the non-Muslim Marriage and Divorce Act doesn't apply to Muslims. So if a couple, Muslim man or Muslim woman and, let's say a Muslim man wants to marry a non-Muslim woman, they can't marry under the civil law. The state law will not marry them. So they can't get married at all. So that's why actually there is sort of a compulsion to convert. But you have raised an incredibly beautiful question. What happens if they got married abroad? Then they came to Malaysia. Is the marriage recognized? As far as I know, when this happens, there is a lot of pressure on the couple, on the non-Muslim party in the marriage to convert. I have to check with my colleagues on this point as to what happens if the non-Muslim party refuses to convert. Is the couple then going to be prosecuted in the Sharia court for khalwat and zina? Will the children be regarded as illegitimate? Will the marriage be regarded as null and void? I'm sure this will also raise issues of international law. if a transaction is valid abroad, if a marriage is valid abroad, and if Malaysia says, no, it's not valid here, that raises issues of international committee, international courtesy. Because I'm just giving a hypothetical example. I don't know the answer. Let us say a Muslim man in Malaysia takes a second wife or third wife or fourth wife, as is allowed here. He goes to England. Can they prosecute him for polygamy? Because England doesn't recognize polygamy. I don't think they will prosecute, because if the marriage is valid in Malaysia, it should be valid there too, as a matter of international committee, international courtesy. So, in my view, the welfare of the child and international law should require that a marriage undertaken abroad should be recognized here. But I don't really know the actual practice. I'll have to check on this. I apologize that I'm ignorant on this issue. I'll have to check on this and possibly let you know. If I can get your email address, I'll be happy to get back to you. Thank you.
You can send the email address to the registration, and then somebody will pick it up. Yeah? There are many questions, but I guess we have to take this as the final one. I apologize to the many of you who have given question here, but we're already hitting 9:30. So I will allow one more question here from Fauzia Sultan, and then we will have to stop. Many Indian Muslim students fall through the cracks due to quota system and are denied of public scholarships and public education. Islam advocates equality, and if Malaysian Constitution is drawn from upon justice and fairness, why such disparities still exist? Not only for Indian Muslims, but also deserving students from other race and religion. This from Fauzia Sultan.
Fauzia, thank you so much for this question. There are several parts to it. First of all, you are saying Indian Muslims don't qualify in many cases for the quotas or reservations or proportions reserved for Malays. I want to point this out to you, Fauzia. The Perlembagan in Article 160 Clause 2, which defines a Malay, and in Article 153, it does not anywhere say that a Malay must be a person of Malay ethnic stock. I know some of you will say, what am I saying? I'm saying to you, the definition of a Malay in Article 160 Clause 2 is non-ethnic. An ethnic category is defined without ethnicity. Can you believe that? I mentioned to you the 4 characteristics. You must be Muslim, you must speak Bahasa Melayu habitually, you must follow Malay Adat, and you must have roots in this soil, either by birth here before Merdeka or descent from one parent. So an Indian Muslim or Pakistani Muslim or Chinese Muslim or Indonesian or Thai or Sri Lankan Muslim is a Malay for the purpose of the Constitution if he satisfies those 4 requirements. So those who are denying to Indian Muslims or to Chinese Muslims such admission are violating the Perlembagan Persekutuan. So that's my first point to you. I think constitutional literacy needs to be improved. The Constitution was not defining the concept of Malay narrowly. Mu'allafs too, in my view, would be included if they satisfy the 4 requirements. Muallafs are converts. So the issue is non-familiarity with the federal constitution. The issue also is of denial of the diversity that actually is a fact of our life. Most of us, if not all of us, are people with mixed backgrounds. The rivers of our life are fed by streams from many sources. So the idea that, oh, you are not pure, therefore you are denied, I think that's against the Constitution. Now, the second part of your question is, Islam requires equality, and so why is this quotas or reservations? That's a tough one, Fauzia, because actually 153 was put into the Constitution as a compromise between the Malays and the non-Malays in 1957. In 1963, 153 was extended, not 1963, a little bit later, was extended to the natives of Sabah, Sarawak. The only thing that I would point out to you is this. Article 153 itself is capable of reinterpretation, and policies, educational policies, licensing policies, which are large-hearted and generous. For example, in Article 153, Clause 1, Fauzia, it says very clearly, Article 153, Clause 1, it shall be the responsibility of the Yang di Pertonagong to safeguard the special position of the Malays, the natives of Sabah Sarawak, and the legitimate interests of other communities. So note, Article 153, Clause 1, legitimate interests of other communities. Article 153, Clause 2, the Yang di Pertonagong shall exercise his functions in such manner as may be necessary. As may be necessary. So in other words, there are no fixed proportions or quotas, as may be necessary. What is necessary may change from time to time. Again, in Article 153, Clause 2, reservation of such proportion as he may deem reasonable. So the word reasonable is used. So Article 153, Clause 1 and Clause 2 are flexible enough to allow the Yang di Pertonagong and the federal government to adopt policies that are not written in stone, that are not carved in stone, that can change from time to time. That's all that I wanted to say. Thank you very much, Anas.
Thank you. I thank you so much, Prof. I think we have to stop here, even though there are many pressing and good questions being posted at the chat group. But unfortunately, I think you're a bit late. We're already a bit late, so I think we'll stop here. Can everybody give? I know we can't really hear the clapping, but let's show. Thank you so much. Everybody give a big hand to Prof for brilliant presentation and really giving us what you call clear and simple ways to understand the Constitution. Yeah, and please do send in your appreciation. We will not switch off immediately. You guys like that. I will pass this to Anindita for a quick wrap up. Thank you, Prof. I'll pass to Anindita.
Thank you so much, Anas. Thank you.
Thank you, Anas, for moderating the session so eloquently. I'm actually grappling for words after this intense discussion, I must admit. Thank you so much, Prof. Shad, for the sharing. I'm sure many in the audience, just like me, would have long had nurtured the desire to have been your student for those who have not had the opportunity to be so. And these MPPI talks are actually giving us that opportunity to be your students and to learn from you, from your, so many years of knowledge, of study, of wisdom of the Constitution. So we'll take this opportunity to extend the heartfelt gratitude for all the learners today. Every session with you is filled with new knowledge and bring a million new questions in our minds. And that is why you see the question and answer session seems to be seamlessly ongoing. And we really look forward to our next session with you, Prof. Many thanks to the participants for joining us today. And Prof. Shad will be back for another session in about a month's time from now, since this is fortnightly. So session is to share about yet another aspect of the Constitution. So ladies and gentlemen, our next MPPI talk will be held on the 5th of August at 8 p.m. A fortnight from now. Please do, so the topic, thank you, Anas, for sharing the topic. A moment, yeah. So we have on Anas. So we'll have the integration of Sabah, Sarawak, and Semenanjung on 5th of August by Dr. Chandra Muzaffar, and then you can see Prof. Shad will be back again speaking about the Malaysian parliamentary democracy on 19th of August. And I think from Prof. Shad's even previous discussions, we have seen it almost, I think almost at every session, and correct me if I'm wrong, Prof, you have spoken about the dilemma of democracy. And I'm definitely looking forward to learn more about the dilemma of democracy. And ladies and gentlemen, please do follow our Facebook page, Taylor's Bachelor of Social Science, as well as Anas Zubedy's Facebook page for timely intimations of our forthcoming webinars. To join us 2 weeks from now, Thursday, 8 p.m. again. Till then, stay safe, stay healthy, and good night.
Salam, good night. Thank you, Prof.
Thank you.